Hello, my dear students. Under labor law, first paper for 7th semester BA LLB program, we are studying about the Industrial Employment Standing Orders Act 1946. And under that head, today we'll talk about the conditions for certification of standing orders given under section 4. And we'll also discuss the appeals against the certification or appeals against the once there is an aggrieved party, maybe the workman, employer, or the trade unions or their representatives, they are aggrieved by the order of the certifying officer, then what is the remedy available to them? These two topics we will cover in today's lecture. First of all, we'll talk about conditions for certification of standing orders given under section 4 of the Industrial Employment Standing Orders Act 1946. Standing orders shall be certifiable under this act if A. The provision is made therein for every matter set out in the schedule which is applicable to the industrial establishment. So, the standing orders would be certified by the certifying officer if the provision is made therein for every matter set out in the schedule and which is applicable to the industrial establishment. And next is B is the other condition is the standing orders are otherwise in conformity with the provisions of this act, and it shall be the function of the certifying officer or appellate authority to adjudicate upon the fairness or reasonableness of the provisions of any standing orders. So, in the standing orders, these standing orders has to be otherwise in conformity with the provisions of this act, and it shall be the function of the certifying officer or appellate authority to adjudicate upon the fairness or reasonableness of the provisions of any standing orders. And if we talk about the appeal for the standing orders or the means once the any employer, any workman, any trade union or their representatives, they are aggrieved by the order of the certifying officer, then how they can move for the appeal against this order. So for appeals, section 6 of the Industrial Employment Standing Orders Act provides for the provisions, and any employer, any workman, trade union, or other prescribed representative who is aggrieved by the order of certifying officer made under section 5 subsection 2, he may appeal to the appellate authority against this order within 30 days from the date on which copies are sent under subsection 3 of that section, means section 5, and appeal to the appellate authority, and appellate authority whose decision shall be final. So if any employer, any workman, any trade union or other prescribed representative is aggrieved by the order of certifying officer made under section 5 subsection 2, he may appeal to the appellate authority within 30 days from the date on which copies are sent under subsection 3 of that section. And appeal will be to the appellate authority, and the appellate authority whose decision shall be final with this regard. And shall by order in writing confirm the standing orders, either in the form of certified by the certifying officer, or after amending these said standing orders by making such modifications thereof or additions thereto as it thinks fit, necessary to render the standing orders certifiable under this act. So So, Section 6 provides that any employer, workman, trade union, or otherwise prescribed any representative, if he is agreed by the order of certifying officer made under Section 5, subsection 2, may appeal to the appellate authority within 30 days from the date on which copies are sent under subsection 3 of that section, and appeal to the appellate authority, and the appellate authority whose decision shall be final. And this order would be in writing, and either means the confirm the standing orders either in the form of certified by the certifying officer, or if they feel that there has to be some changes, there has to be some amendments in the said standing orders by making such modifications thereof or conditions thereto as it thinks necessary, the appellate authority, they feel that it is necessary to render the standing orders certifiable under this act. And appellate authority shall within 7 days of its order under subsection 1 send copies thereof to the certifying officer, to the employer, and to the trade union or other prescribed representative of the workman. So appellate authority, after taking some decision within 7 days of its order under subsection 1, will send the copies to the certifying officer, and these copies will be sent to the employer, to the workman, or if there is a trade union, then to the trade union, or maybe the prescribed representatives of the workman, and accompanied, unless it has confirmed without amendment, the standing orders as certified by the certifying officer, by copies of the standing orders as certified by it and authenticated in the prescribed manner. So once the appellate authority is forwarding these copies to the trade union or to the workman or to the certifying officer, then standing these by copies of this standing order certified by it and authenticated, it would be authenticated in the prescribed manner by the authority. Then it would be forwarded to the workman, trade union, or the if the copies are being sent to the prescribed representative of the workman. And the person, workman, or any employer or trade union or any parties who are aggrieved by the order of certifying officer shall appeal to the appellate authority within 30 days. As I told you, that the time given is within 30 days of such order said by the certifying officer. So the trade union or the workman or the employer, whosoever is aggrieved by the order of certifying officer, then they should go for the appeal to the appellate authority within prescribed time frame, that is within 30 days of such order sent by certifying officer. As I told you that the provisions related to the appeals are given under section 6 of the Industrial Employment Standing Orders Act 1946. So the time limit for the appeal is 30 days. So this is all for these two topic conditions for the certification of standing orders given under section 4 and the appeals given under section 6. So once again, quickly, my dear students, we will go for a quick look what we have covered today. So we have covered the conditions for certification of standing orders, section 4, and we have covered today the appeals against certification, section 6. Section 4 talks about the conditions for certification of standing orders, and the provisions is made therein for every matter set out in this schedule which is applicable to the industrial establishment, and the standing orders are otherwise in conformity with the provisions of this act. Means any standing order you should not incorporate while you are framing the standing orders for the industrial establishment which is breaching any provision of the act. And it shall be the function of the certifying officer or appellate authority to adjudicate upon the fairness or reasonableness. So certifying officer will check it, and if the aggrieved parties are having any objection on the standing orders, then they will appeal to the appellate authority, and then appellate authority should check the fairness, the reasonableness. So the certifying officer and the appellate authority should adjudicate upon the fairness and reasonableness of the provisions of any standing orders. So far the appeals provision is concerned given under section 6 of the Industrial Employment Standing Orders Act 1946. We have already discussed that any employer, any workman, trade union or other prescribed representative aggrieved by the order of certifying officer which certifying officer has made under section 5 subsection 2, these aggrieved parties may appeal to the appellate authority within 30 days from the date on which copies are sent under subsection 3 of that section, and appeal to the appellate authority, and the appellate authority whose decision shall be final. And that order has to be in writing and confirm the standing orders either in the form of certified by the certifying officer. So if the appellate authority is convinced that whatever certifying officer has finally ordered is fine, then in the same form, or after, if the appellate authority feels that there is a need for the amendment in the said standing order, then by making certain changes, by amending, by making such modifications thereof or additions thereto as it thinks fit, the appellate authority necessary to render the standing orders certifiable under this act. And the appellate authority shall within 7 days of its orders, whatever order appellate authority has passed, within 7 days of its order under subsection 1 should send the copies thereof to the certifying officer, to the employer, the trade union or the other prescribed representatives of the workmen accompanied, unless it has confirmed without amendment the standing orders as certified by the certifying officer, or by copies of the standing orders as certified by it and authenticated in the prescribed manner. So it has to be authenticated in the prescribed manner as well. And we have already discussed this point also, that appellate authority means the person or the workman or the employer, trade union or any party who are aggrieved by the order of certifying officer, once they are going for the appeal, or they shall apply to the they shall appeal to the appellate authority within 30 days of such order and sent by the certifying authority. So this is all, my dear students, for today's lecture. Thank you so much for your patience listening, and that these two topics we have covered under labor law first paper for 7th semester B LLB program. And in our next lecture, we will take up some new topic related to standing orders. So thank you so much. And I believe this lecture will help you. Have a nice day. Take care.